learned a lot out of it.
Well, you can extend it if you want to, but I'm not sure if you want to do it.
He is.
What do you
He
want
is
to
here.
extend it to?
I'm just asking for you. It took us,
January till.
it took us forever to get to where we're
But I think going to next session.
They really wanted to engage.
I mean, yeah, we put it. Yeah, it could be 2 more weeks.
Yeah.
I mean, but
I'll let the village committee decide that.
All right, let's call to order the House Judiciary Committee meeting today. If you would, bow your heads with me, and let's, as we always do, begin with asking the Lord to be with us. Lord, we thank you for all the blessings that we do have. We thank you for this beautiful day. We ask you, Lord, now as we meet as the House Judiciary Committee, to, as always, give us the wisdom to know what is best for the people of the state of Georgia and help us carry that out. Thank you for all that we do have. Amen. All right, today we have a couple of items on the agenda. The first one is a study committee, and I'm going to ask Representative Gullett if you would please tell us about House Resolution 1525.
Thank you, Mr. Chairman. Thank you, members of the committee. As some of you know, I had a House bill this year, HB 785, that was in subcommittee. It was related to remote online notary. We weren't able to get that bill across the finish line. There were several questions and concerns that came up throughout the process. And so this is really just the next phase of the process to get us to a bill that all the parties could be agreeable to. I mean, just for everyone's recollection, Governor Kemp issued 2 executive orders related to remote online notary during the COVID crisis. I think they're actually still active today, but this is really just for us to continue the process, study the process, and study how can we get there here in Georgia, and what's that look like for us here in Georgia. Happy to answer any questions about that.
Any questions for Representative Gullett? Okay, Chairman Efstration, your mic number is what? Chairman Efstration.
Thank you, Mr. Chairman. I just wanted to thank the sponsor, Representative Gullett. I know you've worked tirelessly on this, worked with the governor's office, obviously a lot of input, a lot of different intricacies to work through, but certainly the importance of this legislation is clear from what we've just gone through with the pandemic and state of emergency. So I just wanted to thank you for this, fully support a study committee to work out any issues, and appreciate you bringing it.
Thank you, and appreciate your help along the way too. We've had a couple of conversations related to it, and appreciate your support.
Representative Silcox.
The appropriate time, Mr. Chairman, I'd make a motion to pass.
Any further questions for the author? Chairman Silcox has made a motion to pass. Is there a second? There's a second by Representative Oliver. Any further discussion? We have no witnesses signed up. All those in favor of passage, please indicate by saying aye.
Aye.
Any opposed, no. And we do not have any that have zoomed in as of yet. So we are done with you, Mr. Gullett.
Thank you, Mr. Chairman.
Good luck
Thanks.
in rules.
Thank you so much.
Thank you so much. Representative Gullett, when you go out there, would you ask Senator Bruce Thompson to come in and bring his attorney with him?
Sure, thank you.
Senator, why don't you come right here? And there's some lawyer with you we've never seen.
I know.
You can sit there.
I was informed to bring my attorney with me. I didn't realize I was entering a courtroom, but maybe I am.
We're always in favor of those being represented by counsel. So.
Plead the Fifth Amendment, sir.
Absolutely.
Still get my bill passed?
Absolutely. We'll see. So,
Senator, I
Senator,
take this off.
yes, absolutely.
Thank
The speaker has indicated that if you're speaking into a mic or trying to speak to a group, you certainly can do that. We're happy to let you. And I normally say that. Thanks for reminding me. So, Senator, we appreciate you coming today. Of course, if any time that the Attorney General Owens wants to chime in, or you'd like for him to, please feel free. And Mr. Owens, we'll turn that mic on for you when that time comes right there in front of you. What number is that, by the way?
9.
9. Okay. Senator, good to have you today. Welcome, and please tell us about your bill, and we'd be happy to hear from you.
Thank you. Thank you, Mr. Chairman, members of the committee. We should be on LC 345688S. I bring that up out of respect, but also because there's been several iterations, several changes as we've moved through this. If I may, I would just tell you the purpose of this bill, and then I would ask our former Attorney General to kind of take us through this, especially for the attorneys in the room. So basically, my background is cybersecurity. We're in a posture right now in the United States, and particularly in Georgia, where businesses are having breaches on a regular basis. We've all heard about that. Many businesses have done what they believe best practices in trying to prevent that. When something happens when a company has been breached or had a cyber attack, it's not only devastating to the individuals been affected, but it's devastating many times to the companies. We understand that small businesses are the lifeblood, not only of our country, but of the state of Georgia. And so what we seek to do with this is to provide a safe harbor, if you will, an opportunity for businesses to do regular tests, penetration tests within their business, to be able to provide what we call the military SOP, so to speak, their standard procedures that they would do, and then provide some immunity in the event that there was a breach, so that their entire company would not be at risk. And that's really the basic of it. There's a lot of information within this, and if I may, I'd ask our Attorney General, Sam Owens, to be able to take you through the particulars of the bill, if that's okay.
Absolutely. Mr. Owens, you said number 9.
Yes, sir.
Okay. Please introduce yourself.
So thank
Good to
you,
have
Mr.
you with
Chairman.
us.
Sam Owens. I'm here as a member of the Georgia Chamber Cybersecurity Group. I'm not here representing a cybersecurity company. It's solely pro bono volunteer with the Georgia Chamber. We started working on this endeavor.
Mr. Owens, hold on one second. Tap your mic. Let's make sure.
That's not on.
Okay. Hold on one second. Try now. Okay.
Would you like me to swap places?
I'll tell you
I
what.
can move. I'm
No. Try that one. Actually, come to this mic at the table, Mr. Owens. And that should be number 4. Tap into that one. Start over, please.
Thank you, Chairman. So I'm Sam Owens. I am a member of the Georgia Chamber Cybersecurity Task Force. So I am not here representing a business. This is pro bono volunteerism with the Georgia Chamber. Of course, from my prior life, I'm very familiar with cybersecurity and cybersecurity issues. I've worked with the senator previously in this regard. And what caught our attention is that whenever there's a breach, the company is always viewed as the bad guy or bad gal, at the same time that you often have folks in Washington saying that the virus or the hit was previously never known. You know, that the bad people seem to be a step ahead of the good folks. So even if you have the software, the technology, it's not a guarantee. It doesn't guarantee anything. Ohio came up with this affirmative defense, and as soon as we saw what Ohio did, we were interested in it. So what this bill, in essence, is a Georgia version of the Ohio bill that says you can either follow cybersecurity controls or you can be certified by in essence, a national cybersecurity recognized authority. And this bill also takes into account that there's a difference between a business with 10 people and a business with 50,000 people. What I think in particular is really good about this bill is candidly what it holds the business to. You know, the second page is frankly more what's the definition of personal information, et cetera. The meat of the bill, frankly, is 3 and 4. And when you look at 10.1.923, what that's really requiring is that you have a program, that you hire staff, that you regularly make sure that everything's under control, that you're regularly updating and training. And you can't underestimate the value of the training. If you have the program, but you don't thereafter regularly train, it's frankly worthless. And then when you look at line 104, for instance, it's the periodic test. That's really crucial. It's not just the assessment of the risks, but it's the test to make sure everything's working when you literally reach out to folks to try and break into your system, because you learn more, frankly, with that exercise, that tabletop exercise, than anything else. I mean, folks that you hire can say they're great. Folks that you hire can say they're assessing the risk. They're constantly upgrading all the technology. But the independent folks that do the table talk exercises are the best thing out there to protect not only the business, but their clients. So this provides the two-way, both you show that you really do everything. And if you don't do what's in here, then you're not protected. Then you don't have the affirmative defense or the certification. And there are at least 2 national certifications recognized in this area. And it's the same ones the federal government relies on in that regard. So it requires, another nice part of it is on line 117, it says within 12 months of the breach, you had to go through this assessment. So, once again, you just can't hire folks. You can't give them fancy titles. You can't keep buying software and saying, okay, I've done my part. The testing is everything here. And this puts frankly, what's not an easy burden. It says within 12 months. So by definition, that means you regularly have to make sure that you're doing what you're saying here. So once again, this idea came from Ohio. I was telling the senator, I think the language is frankly really thorough in the bill. A lot of times when you look in these bills, it doesn't require as many steps as this bill does. So I think the senator, this is not a minimalist bill at all. This is actually a healthy obligation on behalf of any business. And I think it's necessary because you don't go a week in this country without someone being breached. And you want to provide an affirmative defense for those folks who are actually going through a significant effort to protect versus those folks that frankly may not be doing enough. No one wants to protect the folks that aren't doing enough, but we want to protect the folks that are. And I think that this is very good in that regard. Thank you, Mr. Chairman.
Mr. Owens, let me start by asking this question of you. What is current Georgia law in this area?
Georgia law does not have much in this area at all. It literally defines personal information in several statutes. And it says that if you have a worst case scenario, you frankly tell the feds. We don't even have a bill in Georgia that says you've got to tell the Attorney General. So we're going here from step 1 to a state of the art.
And you said Ohio has enacted something similar.
It would now be 2 or 3 years ago, Chairman.
Do you know if any other states are following the trend?
Yeah, there's a whole group of states that have been active. Ohio was the
you're
first
welcome to
state.
jump in here at any time. Yeah.
No, Ohio was the first. Several states immediately followed. We started working on this last year, and we're working with Senator Thompson during last year's session. But in dealing with some of the legal issues in Georgia, it was decided that we frankly needed to be more detailed in what was required of the businesses rather than making general statements. So that's why in the bill before you, it sets down a whole bunch of steps those businesses would have to go through.
You can probably think of a better example of a safe harbor. I was sitting here trying to think of another example in our law of safe harbor. I know that.
Well, I mean, with regard to paramedics, with regard to police officers, but this is simply saying, and of course, you've got another safe harbor bill proposed with regard to COVID this session. The issue here is if you literally do above and beyond, don't be treated the same way the folks who don't do are treated.
The other question I had is that I noticed on line 28, there's a definition of covered entities. It means a business that accesses and talks about personal information after that. That term business. So let's, for example, a church that keeps on record my credit card number because that's how I contribute. Would they be covered under this bill?
Yes.
The definition of business stretches that far?
Yes. And candidly, under the federal FTC law in this area, it in some areas is not nearly as good.
So is that definition attached to some other federal regulation?
In
or,
the-
or is it going, or is what a business is clearly within the scope of our code?
So I don't frankly know of a definition of business within this section, Chairman,
Right.
but I would tell you in the other existing Georgia law that we have, it frankly relates to the size of the business and it provides nothing with regard to the small business. And this actually does protect small business
How so?
because there's a provision, Senator, you may know the line quicker than me, where there's a line that says, it says like on line 80, the size and complexity of the covered entity, the nature and scope of the activities, that's all based on, the resources available to the covered entity. So by definition, that's referencing a small business, a church versus
And I'm sorry, where were you again in there?
if you look at, for instance, lines 80 to 85, Chairman.
Okay.
So the definition of reasonableness is based on the factors on 80 to 85. So if you're talking about a 10 employee business, you're not expecting them to do the same steps as a company with 2,000 employees or 5,000 employees.
And I was actually thinking, I know my doctor's office back in the Augusta area
Mhm.
is a large entity of
Mhm.
40 something general
Mhm.
practitioners with several
Mhm.
offices. And of course, when I go there, I give them my credit card to
Mhm.
cover whatever is needed. So I assume they're now going to have access to my number.
Yeah.
However, I would also think of several miles up the road in a small town outside the Augusta metro area, there are some doctors that still are solo practitioners. And my suspicion are they're changing like the rest of the world. They now are probably taking debit cards and credit
No,
cards.
absolutely. But let's face it, that, and the Georgia Chambers, frankly, tried really hard to deal with this issue. Not everyone has the same resources.
Mhm.
Folks in Hiram, may not have the same ability to pay those big bills as the folks in Augusta.
Mhm.
And it's important to,
On the other hand, I would think Synovus or whatever company it might
Absolutely.
be that manages millions of people's credit card numbers, and we know they get hacked all the time, would have a different level. And I'm trying to understand that. You think starting in line 80 covers that?
yes, sir, because the more complex, the larger the size, that means the reasonable definition is going to be altered.
Okay. All right.
Mr. Chairman, may I?
Please,
back-
absolutely.
Yeah,
absolutely.
earlier you're
That's what I
talking
meant
about
by chiming
states.
in at any time.
As the Attorney General was going through, or Sam was talking about it, I was looking here, Utah, Texas, Virginia, Minnesota. I mean, many states are now addressing this right now. It's going through this for this very reason, to provide some defense for our small businesses. Many times, and we all know this, many times businesses aren't necessarily keeping those records in their small operation. You're using third-party vendors. And so it's not like you're writing it down already on a piece of paper and sticking it somewhere. So the exposure for a lot of these businesses isn't just necessarily the credit cards, but it's the personal data they have with their consumers that they're dealing with, the clients.
The reason the definition of business is interesting to me and on line 28 and what it actually covers is I'm thinking through, this effort for people to use debit cards and credit cards and accept them is only going to grow. Or personal information with any kind of number that gets to money. I'm thinking of the Boosters Club at my local high school when they do a fundraiser. I'm sure that they are going to, if they don't already, when someone buys X amount of things they're selling to raise money for the kids to play football or whatever sport it is, that they're probably going to at some point take debit credit card number. Now they are a sub entity of my local school system, which should be very sophisticated because they have all kind of kids' informations and whatnot. So is that Booster Club going to be held to the standard of my school system because they're associated with it?
Mr. Chairman, I hesitate to give you a black and white answer there because we all know that numerous booster clubs have had significant issues with regard to fraud.
Yes.
And treasurers of those clubs being arrested /
Yes.
indicted, and that often those accounts are not placed in a school system account, but in a separate booster club account. So I don't think one is able to make a clear statement of whether or not they're frankly treated as a subgroup of a school district or a nonprofit associated with a school district.
Likely the Catholic Church in Augusta, when they hold a fundraiser of some sort, are they going to be held to the level of the diocese or Rome?
Right. Of course.
Versus being a church with 100 parishioners.
And that's frankly, I think, a positive part of this bill is it has that differentiation.
Where?
Well, when we're talking on lines 80 to 85.
But what distinguishes the church in Augusta with the Diocese of Savannah?
Well, when you're talking about the scale and scope, that's certainly the intent.
Okay. All right. Let's see. We have some other folks with questions. And Ms. Silcox, are you number 3? Okay.
Thank you, Mr. Chairman. Thank you so much for bringing this bill. I have 2 companies in my district constituents that have had major problems with this. And it's interesting to me that there's not cybersecurity insurance listed as one of the requirements. But to me, both of these companies did absolutely everything they could. They had cybersecurity insurance. They did all this training. They have a designated IT department. They did everything they could. And both of them are involved in major class action suits now as we speak about the breach. And they did everything they could. So I think we really need this for business in Georgia. And I think it's a great bill. And I appreciate you bringing it, Senator Thompson.
Thank you. May I respond to
Please.
that?
Mhm.
So cybersecurity was certain. A couple of years ago, I had the bill and we worked on some legislation. Or actually, I had the bill. We worked on drafting and a floor leader carried it for the governor. It had to do with introducing cybersecurity insurance for our state because, frankly, we didn't have that as well. The reason we didn't have it is, and many of you understand insurance, is to go through and create a poly for someone, they have to understand what the risk is, right? Obviously, it's very difficult for these insurance companies right now
ascertain the risk,
to quantify what the risk is for a small company to then be able to extend a policy to them. So I believe something like this and I have an insurance background as well. In my opinion, by being able to provide this, it will then afford the ability for them to go out and get insurance because insurance companies will then see there is a standard versus creating a huge standard that various companies can do.
I agree. I think it provides certainty, certainly for the liability. Certainly.
Thank you.
Thank you.
Representative Rich.
Thank you. I wanted to ask if you could explain how it would be different if we had this statute, because wouldn't these be arguments that a business could make anyway if they were sued? If they were to show that they had all of these procedures and policies in place?
The affirmative defense is a far stronger tool. You're able to candidly file a motion based on the affirmative defense that otherwise would automatically go to a jury.
So having this in place would actually prevent a person from bringing their case in front of a jury.
If they in fact presented the appropriate level of evidence.
Compliance with the
Right,
statute.
absolutely.
On a motion for summary judgment or a motion to dismiss?
Yes.
Okay.
Chairman Administration.
Thank you, Mr. Chairman. Thank you, Senator, for your presentation, and thank you, Attorney General, for the explanation given. I just have a few technical questions, and the Attorney General probably remember when he was in office, I would come to him with concerns over scammers or exposure of data. I think that user data is an incredible resource that these companies utilize and certainly take the benefits from. And when there is a breach, recognition of the harmful impact to citizens is just is something that I think we all appreciate, but it's certainly first and foremost in my mind as I consider these bills. So just a few questions. First of all, between line 41, defining personal information, maybe I missed it, but I didn't see birth date included there. And I'm familiar with, in the court system, birth dates must be omitted except for the birth year because of the potential harmful consequences to disclosure of a birth date, identity fraud consequences in a public court filing. And I was my first question was if I've missed something or if that was intentionally omitted.
I'm sorry, the speaker's here.
Yes.
I know we didn't intentionally omit that, Chairman, but we worked on this with the Chamber and many other organizations, and this is kind of drafted through various people working on this, but we didn't intentionally omit it.
Hold on, Ms. Silcox. What, you number 3? Go ahead.
I'm just curious if it would be possibly included under B, other unique ID number issued by the government, since even birth certificates and all those things are issued by the government. I'm just curious.
Well, to clear up any ambiguity, I'd certainly recommend, I don't think it would be included, but I appreciate the point. I think maybe to clear up any ambiguity, that might be a friendly addition to the bill. Mr. Chairman, may I ask a few more? So also, since I've become a father, I'm very cognizant of identity theft of children, many times infants, and it's not recognized until they reach majority and there's a problem with student loan applications, car applications, things like that occurring. I guess my concern is that child names might be associated with user accounts. And here we have here, it's in combination with, I see in line 42. So it would have to be associated with the first and last name of the parent, presumably. But I'm wondering if the author would be agreeable to including child identifying information as well as the personal information within the definition.
Certainly, I'd be open to something like that. Anything we do that would strengthen the bill, but not in any way create harm to it, poison the bill, I'm certainly open to.
Those are more technical asks, but if I get into the real heart of the bill, I'm looking at line 64. This is the reasonably conform language.
Right.
And is that, Mr. Olens, is that a legal term that's used elsewhere where practitioners in this area would be able to clearly define for the court what reasonably conform means, or is that a question of interpretation depending on the circumstances?
It's common in these types of statutes, Representative, but it frankly would be enunciated in the sections below.
I guess what I'm getting, we have reasonably conform there, and then you'll note it's reasonably conformed to 10.1.923A, first of all, and B is identifies reasonably foreseeable internal and external risks. So we have a double reasonable there. Reasonably conforms to identifying reasonable risks. Is there any concern that that might confuse the court? I assume we're talking about a motion for maybe a pretrial proceeding or a question that's being put before a jury. Is that going to cause confusion with the double reasonable?
I'm sorry, Representative. Tell me where the second reasonable is. Which line is that again?
91.
Okay. So I think those are frankly two different issues. The one is with regard to the general statement, which I think relates to 10.923. 923, where you're referencing there, I think is specific to the risks. And I'm not trying to be cute or whatever, but I do think those are two different things.
That's fair, and I'm sorry. Actually, I think the second reasonable is line 89. I misspoke. We have that under 1, 2, and 3. Do you follow what I'm saying? If we have reasonably conforms to reasonable safeguards, reasonable technical standards, and reasonable physical safeguards, Well, that's just something to think about. Maybe, I'm always trying to picture how this would be implemented in court, and I think we want to be as clear as possible. Mr. Chairman, if I could, I just have two other questions. Thank you. It looks like, if I'm reading this correctly, the affirmative defense would apply if there's reasonable conformity to 10.1.923A, what I was just talking about, or that's in line 65, or receives a certification consistent with 10.1.923B, which as I look at B then, which is on line 114 to 120, it's either 1, substantial compliance with the provisions of this article, or 2, has within 12 months prior to the data breach, and it falls there. It's employing a security company. I guess my question is as I read this, employing an independent security assessment firm would essentially forgive compliance with all the preceding requirements because of the or. Is that true?
So it's requiring that firm be credentialed security professionals and receive a certification of adherence to a widely recognized information security standard. So there's only a couple of those companies that meet that requirement. So it's saying you can do everything that's outlined in the bill, or you can hire one of those companies that has a certification that mandates that they're going all those steps, and they have to go through all those steps with your company before they can say that your company has done it. To me, the issue is more who's taking those steps. And in some ways, the latter is better because you're relying on a national certified process versus what could be, in essence, a company process.
Would it cause any harm if that was an and as opposed to an or?
Yeah, because
So,
I'm sorry. If you make it an and, then there's no reason why you would do the first one, and then you'd have everyone using the second. And candidly, the second's a lot more money. So you're then hurting a lot of small businesses that are going to be adversely affected.
Because what I'm really driving at here is, would there be any harm to requiring that the certification adhere to these very carefully explained standards that are provided in the bill?
So my concern, again, Representative and Senator Thompson may be better at this, is the cost associated for a small business is a different thing entirely. When the chairman's talking about Synovus, that's a different, God knows how many millions of dollars a company like Synovus spends every year. I'm thinking it's at least 8 figures, if not 9. And when you're talking about a company with 10 or 20 employees, it's so different that you're making it unaffordable.
So if I could just conclude with a comment. Thank you, Mr. Chairman, for the leeway. I am all about helping small businesses. I really am proud of my record up here working on behalf of small businesses, but I'd just like to say something about collection of personal data. Personal data being collected by private industry, it's not like collecting certain resources or collecting widgets. It's collecting something that if it becomes breached and that information is out there and accessible, it harms people who did nothing more than bought something through that company, went through and processed what they did. By a company agreeing to, regardless of the size, collect that information, presumably and likely for profitability reasons, there's a real responsibility to ensure that people aren't harmed as a result of a breach that results. And so, certainly with that risk on the table, I can certainly understand why we would want to protect Georgians to ensure that we don't have lax standards in that regard. And, just want to make that statement. Of course, I'm happy if the sponsor, Mr. Olins, have any response to that. Thank you, Mr. Chairman.
Mr. Chairman, may I respond? And I appreciate the concern, because I too concerned with that. I went through a data breach where my name and my identity was stolen And so personally went through that. And that's one of the things generated the interest in this. I would say this not as an excuse, but every single one of us, our information is out there, right? What we're doing with this right now is trying to say to the consumer, we're trying to put in place to the small business that you're of which doing business with, that they then can say, we're holding ourselves to standards. So it is in essence an opportunity for someone to look at a business and go, hey, are you meeting these standards? And as maybe a third-party vendor, you're able to look at some of that as if that's not out there right now at all. It's kind of at your risk.
Your
So
point would be that if we pass this, the NFIB that represents small businesses are not going to have a pamphlet that they're going to hand to, or you can go on their website
good.
and say, hey, if you're a small business, you need to do these things, because if you do, you fall under a law that will help protect you if you do good things and still get breached.
Sure.
And so, let's see, Representative Reeves.
Thank you, Mr. Chairman. So I'm I'm very much seeing the tension in the issue here with the protecting the small business and exactly what Chairman Efstration was talking about. And I'm looking at this as not as the words on the paper, but trying to play it out as a litigation in my mind as a lawyer who does a lot of civil defense work. And, and Mr. Owens, what I really, as I look at lines 68 through 85, which is essentially B and C of 10-1-922, I think that these, if we're in it would be unless there was just no security system at all, then I can't see how a motion to dismiss would even be a discussion, in this context. And so I'm trying to look at this through a motion for summary judgment. And these items that are listed in B and C are so subjective that it just seems it would be very hard for me to imagine a fact pattern where a judge wouldn't find an issue of fact for the jury to determine. And I mean, so for my first question is do you agree with me that I just think the way this is set up is going to be a very difficult to establish your case in a motion for summary judgment, because I think it's just going to be very fact-based, and I think those are issues for the jury. What are your thoughts, again, looking at this through an actual, through the eyes of litigation?
So nothing is foolproof, and no bill is going to be perfect in this area because the technology moves so much faster than the law.
Mm-hmm.
Clearly, the national certification provides more protection,
Mm-hmm.
but only the big guys can afford that. I tend to think that the plaintiff would have the obligation to frankly present evidence that the company did not do what's in 68 to 85 in order to create a jury question
Mm-hmm.
at that point. And, the one thing I learned early on in the law is the lawyers actually make a difference, and affidavits are really crucial in summary judgment cases. So the better the affidavit based on what actions the company took, the greater likelihood you would be wrong, and the less steps they took,
Mm-hmm.
the more likely you'd be right. So if I were one of those companies, I'd really want those affidavits to be able to fully
Mm-hmm.
appreciate what was done. This whole issue about protecting small versus large, representative, by definition, there's always going to be concerns there. But under this rubric,
Mm-hmm.
buying a software program and installing it on your computers is wholly insufficient.
Mm-hmm.
So irrespective of jury question or not jury question, getting back to what Representative Efstration was doing, this is substantially increasing the likelihood that the PIN won't be released.
Mm-hmm.
And there's a value separate and apart to that statement.
Sure, if everybody, there's an incentive to have a more beefed up security system, then there ideally will be less breaches and less victims. Like I understand that, and in support of that, I'm trying to, again, and I didn't read this bill before we got here today, and I apologize for that. So I'm thinking through this in real time, but the way I essentially see this, I see it probably being difficult to resolve this kind of counter allegation in a lawsuit pre-trial. And so am I right that essentially 10-1-923 would more or less serve as the jury charge? If the affirmative defense is raised, the jury would be charged to determine all of the things that are found in 923.
In those cases and where it went to a jury, I would agree with you 100%.
So how does this, so I understand what we're doing here, but what if there is, if the defendant has met the obligations to establish that they do have these security measures and these efforts, implemented, but there is simultaneously with that, separate and apart from this, there's negligence on their end that is shown, then in your mind or your intentions, does that prevent it? Where would a judge be prevented from charging a jury with that affirmative defense and the jury charges if there was simultaneously a showing of negligence, even though they had checked the box on a lot of these things, but there was also an act of negligence? Would the intentions of the bill be that a jury would still be able to contemplate the affirmative defense along with the negligence, or would is there a stopgate that would prevent or require or give discretion for the judge to not allow the affirmative defense into the case or the jury charge to the jury if there's also negligence accompanying this?
So once again, we're talking big picture rather than small. I think the intent of the bill is where there's negligence that wouldn't provide an affirmative defense. So, so let's say, for instance, a company had not updated the software in 2 years. That wouldn't be consistent with the rubric here.
But what if they had, and there was still some other type of negligence that's outside of the boundaries of what we're looking at on the, there's some other form of negligence that is outside of they've checked all these boxes, but they were negligent in some other way. Is it the intention that they would still be, would they be prevented from raising that affirmative defense because of external negligence that's not related to any of these factors, or would it be strictly a discretionary call by the judge? I mean,
I think the fact patterns would be so different that it's hard to make a general statement. As a general statement, if you do what's required in Senator Thompson's bill, you should be protected. So when they haven't done that, and when you're saying some other type of negligence, I'm trying to figure out what that, frankly, other type of negligence would be.
And I mean, that's the problem with technology, right? Is that it's so. He knows a whole lot more about technology than I
Mr.
do,
Jones
so.
may have an answer for us. Mr. Jones.
Representative Reeves, at least as I was working through, Representative Reeves, as I was working through this with the senator, in my mind, line 71 to me was that catch-all. So hypothetically, you use admin as the administrative password. You don't update your security patch. You do not have physical security at your data center. I mean, I can keep going if you want, but I think I'll bore the committee. But at the end of the day, if you don't do all those things, or at least one of those things, Representative Reeves, in terms of, I'm trying to come up with every negligent act, which would be too exhaustive of a list. In my mind, you have not protected against anticipated threats and hazards. And at that point, you lose your ability to claim the affirmative defense, at least as I was working with Senator. Yeah, okay. Well, thank you.
I agree.
Okay. Thank you, Mr. Chairman.
Did you have another question you want to ask?
It's sort of like the person that has the password.
And we have seen both. And we have seen that.
That's bad.
Please change it today, sir.
Okay, hold on.
And I think at the end of the day, especially with our company as an example, we protect all the way from the Fiat Chryslers and Walgreens and BMWs worldwide. all the way down to smaller companies, not nearly as large as those global operations. At the end of the day, we work in concert with our data hosting facilities like AWS, Azure, Rackspace, et cetera. And to Chairman Frustration's comments, in so many ways, the market itself is effectively making its choice, because if you do, in fact, have a breach, that is top of the fold front page. So we are in so many ways holding each other accountable to this. And I think so many people are becoming more and more cognizant. So I think this gives us at least that opportunity to provide the businesses with some type of sliding scale in terms of responsibility. And I know, at least speaking as a company that isn't as large as, I'll say Fiat Chrysler, but definitely growing in the software space, we appreciate this type.
Well, let me ask you this then. Sure. This is what I'm talking about when I'm talking about off the paper of what we're looking at here. Let's say that the company that we're talking about has complied with all these things, but then they have an employee who passes along the information to somebody else, and then that information is used to compromise the system. And then it was the employer negligent in retention of that employee, or was the business we're talking about? Is there some kind of collateral negligent retention of employment claim that, because frankly, business litigation gets complicated really fast. And if you're a plaintiff, you're not going to go after that employee who probably has very limited resources. You're going to go after the business. And so, and plaintiff law gets very creative to its credit. And so when I talk about things being off the page, that's what I'm talking about. And how does this factor into, a litigation or a claim such as that? And I know we could sit here and come up with hypotheticals all day long, and I'm not trying to split hairs, but I'm just trying to think through this as practically as I can right now and have this discussion.
It would seem to me that when you have an employee that has the appropriate education and experience to be one of those individuals you specifically place as part of the cybersecurity program, and they commit a crime, mm-hmm. absent any evidence to that company, that should not be liability to the company. That's not negligence. I mean, I can't.
But what if there's a negligent retention? Like, what if there's something that the employer should have known about that person?
Well, that's different.
When
that's of course different.
But and all of those pathways are attempted to be used to get to the entity that has the resources, and so again, I'm trying to wrap my mind all the way around this thing. So.
If I could say one more thing, Chairman. With regard to Representative Frustration, where he talked about the reasonably conform on line 64 and the reasonable administrative safeguards on line 89, Representative, if you look above on 63, it uses the term administrative, technical, and physical safeguards that reasonably conform as compared to just the administrative. So when we're talking about the two sections, the first one is frankly far more specific and covers far more material than the later one on line 89. So there is a rhyme and reason to have the two different terms as they have different meanings within there. The one on 64 clearly includes much more in that context.
May I ask a follow-up?
Sure.
Are you saying that the reasonably conform is to describe the physical safeguards in line 63 only?
No, I'm saying that when it's reasonable conform, it includes administrative, technical, and physical safeguards of 10.1923, which is a broader set of responsibilities.
So that those administrative, technical, and physical safeguards that reasonably conform to
Section A
1, 2, and 3, which is reasonable administrative safeguards of the following to reasonable line 99, reasonable technical safeguards, and 106, reasonable physical safeguards.
Right, so it's literally subdividing in that section what's on line 63, I believe.
So I guess just so that you're clear on my question, it's reasonably comply with reasonable safeguards. That's the double reasonable that I think may cause some ambiguity. Maybe it's just me, but that's all I was attempting to raise. And sometimes statutes are intentionally drawn in a very broad manner so that if you get anywhere close to the target, it will suffice. And maybe that's the intent here.
I can simply say that, and the senator can certainly speak, no one, the whole intent of this bill is for it to be maximal, not minimal. So there's no language placed in here to lower the bar. And clearly you have, similar to your prior comments, if you have a suggestion, we're open, we're listening to that. There's no intent to weaken anything.
No, we wordsmith in Judiciary is all we do. So
it's never happened before.
That. Yeah.
Let me. You want to comment on this?
On that.
On that? Okay, go ahead.
So real quick, and I don't want to speak for the senator, but I think the removal of reasonably from line 64 doesn't lessen it, because of the fact, to Chairman Efferstration's point, we have reasonable inside of the coverage that they're saying in subsection A. I do think B is going to be triggered more often than folks in this room think, and that's going to move you to lines 114 to 120, everybody, because I mean, I can speak for our company. Since we have about 6 of these certifications already, we're just going to keep the certifications and use that as our, hey, look, we're doing the right thing. So many companies that are taking on this type of data have already moved to do that, because frankly, inside of their contracts, their customers are requiring them to do that. And then you're seeing some states and also some countries, if they're international or not, having that requirement. So I don't think we should lessen the fact that the bill does have 114 to 120 as a way to show that demonstrative security. So
my concern, I think, is an indication of exactly what you're talking about. This is going to become the standard, and if you don't do this, you're going to be negligent. Which in and of itself is not a bad thing, because the companies are realizing what you're saying. That's why I'm asking the questions about the small guys.
Well,
because once this becomes the standards, I'm concerned about them. I mean, I think we are helping move people toward a better thing. We're just going to leave some people behind, and that's what I want to flesh out, I guess.
So, Mr. Chairman, if I may,
Yeah.
it is a delicate balance between the small guy and the bigger ones, but many companies in this vertical are moving to third-party vendors anyway. So their primary business is this. They're utilizing a third-party vendor because they know their exposure is this anyway. So that is already happening, but those that might be caught in the middle of it that may not want to go to a third-party vendor, this is where they're going to be captured, if that indeed the marketplace pushes them to that.
Representative Wilson.
Thank you, Mr. Chairman. Mr. Attorney General, it's good to see you. Forgive me, I came in after the presentation began, so I missed your introduction, but are you here representing a particular entity today?
No, not at all. I'm here pro bono as a member of the Georgia Chamber Cybersecurity Task Force.
I appreciate
And
that.
in fact, the firm's already yelled at me today.
Get back to
There's other clients I could
Sure.
be working on. Yes.
We all identify with that.
Sure.
Yes, you do. Yes.
You have a lot of sympathizers in this room, I can assure you. So my question, and neither you or Senator, is I understand as a practicing lawyer, the strategic advantage to having an affirmative defense that you went through with Representative Rich before, but what is the public policy that we're serving by providing these businesses with an affirmative defense?
You're assuring that they're going to take the appropriate steps to provide greater protection to their customers. There's an incentive to spend those dollars to have greater technology in use at their company.
So if that is the case, and I believe it to be so, then my concern is on line 116 that we're drawing a line in the sand for what's reasonable and what's not, but we're only requiring substantial compliance with it. And I've been sitting here trying to think of another example of where we only require substantial compliance for an affirmative defense. And I can't think of one. Every tortfeasor substantially complied with what was reasonable until they crossed that line. And now we're saying for businesses who are accused of crossing that line, they get the benefit of substantial compliance, even though potentially they're across the line because the data was breached.
I mean, once again, this isn't an area where anyone was trying to let stuff slide. If you have another word that you potentially prefer.
Well, I would. Why not full compliance with this code section, or with the article? I'm sorry.
That's black and white, and we're not in a black and white world when it comes to cybersecurity. That's my concern. You know, what you do June 17, June 18, whatever today is not the same maybe as July 17 in that area. And that's, for instance, why there's the 12 months in the other section. The technology is moving so fast. I'm not sure what full compliance means, because it changes with every breach that folks learn from it. And, you know, how often do you get that notice on your computer that it's either doing an automatic upgrade or it's asking you to check to do the automatic upgrade? And I mean, to me, full compliance is, we really don't want to help you, just due to the nature of the technology.
But haven't we outlined in, you know, these articles before, or in the rest of the article, what compliance would look like?
When you say full, I candidly find that very confusing with the other sections, because no one's got great definitions of the word full in this regard. Clearly you want a good faith effort. Good faith probably isn't as strong as substantial.
Sure.
So once again, it's not someone trying to minimalize, but full to me is really problematic, because full today isn't full 2 months from now. I mean, the technology is going at warp speed, and no one else is moving that fast.
Mr. Chairman.
Sure, Senator.
Yes, if we're not careful, the intent of this bill is to provide an opportunity for some protections. We'll set the standards so high that there's no way anyone can comply with it, which is where we'll find ourselves today, which is exposure, possible exposure. And so we're trying to create a standard that companies can comply to, because many smaller companies, they're not even sure what they're supposed to do other than what they're told to do. And that they're getting from different places. So we're trying to create an environment, so to speak, to be able to comply to for that safe harbor.
Representative Silcox.
Thank you, Mr. Chairman. I would just respond to Representative Wilson that I really believe that the standards starting in line 68 and the administrative, to Representative Jones' earlier comment, that those are so broad that, you know, that arguably people are going to trip up just on those, because protect the security and confidentiality of personal information. I mean, that covers the waterfront, guys. So I do think that substantial is adequate here, because they're stated so broadly. And the default, of course, is to be with a very expensive security company, as Representative Jones referred to, you know, in terms of cost. And I think you have to have both to protect the little guy, as not everybody can afford the very expensive security company.
Mr. Wilson.
Just a quick response, Mr. Chairman. I'm very sympathetic to that, and I don't think there's any malintent here at all, and I don't mean to imply that. My concern is just what's the harm in allowing a jury to see that and letting the jury decide?
The cost of defense is prohibitive. I mean, for instance, and Senator Thompson may be better, you know, I'm sufficiently old that I'm still trying to figure out what the heck metadata means.
Mm-hmm.
But, you know, when I first started doing litigation and doing discovery, I knew what litigation was. But now when I see questions on metadata and all, it's not me who can do that, so I got to hire someone to do that. If you're a small business and all of a sudden you're being asked to hire people for those levels of minutia of data, you know, when I started, we thought we were really high class when we had an IBM Selectric. But now every time you make a change on a document, there's metadata that for a small business, I just don't know how they would possibly deal with that.
And I would just argue, Mr. Attorney General, that that's where that should be considered when accepting the responsibility that Representative or Chairman Administration mentioned, that if you're going to store this personal information for a business advantage, then that is a risk that you must consider.
I would simply suggest, Representative, that it's not an either or. You know, either you stay in business or you don't stay in business. You want to encourage small businesses to thrive,
Sure.
and to grow. And in this environment, the cost is prohibitive. If you go through all the steps that Representative Silcox was talking about, that is not an easy swim. I mean, you're actually challenging folks to show seriousness. It's just not so easy to go through those steps at that point.
But every litigation resulting from a data breach is not going to be a national multi-district class action, right? I mean, that's good.
You
The big
hope
ones
so.
will be, but
We certainly hope so.
sure.
But for instance, I will tell you, in my AG world, I had a school district call me one day and say, you know under Georgia law, I don't need to tell the Attorney General. And I think this only related to 10 of our school teachers. But just because I want to show transparency and good faith, I'm calling you and telling you we've reached out to those 10 teachers, et cetera. For that school district to get sued by one of those school teachers, thankfully they were not. But the data had been released. You know, they were calling me, telling me it did happen. There was never a newspaper article on it. The teachers understood that the school system was doing the best. I can't imagine what that cost what that expense would have been. And once again, when you're dealing with the difference between a Cobb school district and a Appleton County school district, it's a totally different ballgame.
Representative Reeves.
Thank you. I'm just going to throw something out there, and I don't think that we would be able to resolve this language today. So if we come back to this bill, what I would ask for you to think about is inserting in line 87 at the beginning, and I'm going to read this, but I'm paraphrasing an idea. To insert at the beginning after A, absent some other showing of negligent conduct on the part of the defendant that contributed to the breach, comma, a covered entity shall be deemed to be in compliance, etc. I think you understand what I'm getting at, and is that something that you could be open to, or is there a way to perfect that, or is that defeat the purpose of your bill? I want to be clear. I like what you're trying to do here, and I think that this kind of law does help protect all of our data, because I think it changes the industry mindset. But what I don't want this to be is to be an affirmative defense that serves as a shield that is inappropriately used, claimed, or allowed by a judge when there was other negligent conduct. And so what are your thoughts on that?
My initial thoughts are that it would be better if it said something like absent a showing of willful negligence rather than simply negligence. Senator? I mean, my initial thought was using willful negligence rather than negligence, because I'm still a little concerned that you're putting too much blame on a company for the acts of an employee that they frankly didn't previously know about. And that when you put the word willful in front of it, for instance, it provides some protection in those instances.
And And to try to broaden the spectrum, I mean, the employee example I used was just the one that I could come up with in my mind of something that's outside of what we're talking about here. I'm sure that there are, we could probably sit down and come up with 10, examples of that. And that's what my goal is here. It's not just specifically to that specific example I gave, but
candidly, Representative, actions of employees,
mhm,
as you know, are frankly a large part of the problem.
mhm,
I mean, you don't, honestly didn't come up with something that is infrequent. When it occurs, often it involves an employee.
mhm. And I'm certainly open to qualifying negligence with willful. I think that, again, what my goal is in this line of thinking, and I might be going down the wrong road on this, and I might wake up tomorrow and say, what was I thinking? But my goal is I don't want this to become a shield that is impenetrable, if that's the right
Sure.
word. And because I do think there's a balance here, and I say that in complete support of what this is looking to accomplish. I'm just trying to talk about how to balance the reality of a claim there. So,
Representative Rutledge.
Thank you, Mr. Chairman. How did they get this passed in Ohio?
Candidly, it was far easier than our experience today. And candidly, it was because there was a realization that business was really hurting due to this issue.
Maybe we could zoom them in.
Mr. Reed, do you want to come to a microphone up here? Try that one right there. Yeah, that way you can put your computer in front of you. I think that is number 13. Please introduce yourself. Tell us who you are, who you're with, and good to have you. And let's tap that mic. And yep.
Thank you, Mr. Chairman. My name is Jordan Reed. I'm with Georgia Trial Lawyers Association. And we came today just to bring up a couple of questions we had about the bill. Specifically looking at it, I wanted to draw the committee's attention to line 62. It reads that if a covered entity maintains its own written policy, then it will have an affirmative defense provided the policy complies with subsection B. However, if you then bring your attention to line 116, it says, as we've been discussing just now, substantial compliance is an affirmative defense. So this is based on an intent of a company versus what they did. If they had a policy and tried, then they have a defense. We do not allow substantial compliance in other torts or criminal law. I substantially complied with the speed limit, but then ran the red light. It's not a defense to breaching my duty to not run the red light. So Chairman Reeves brings up the idea of potentially adding some language regarding showing some other showing of negligent conduct. And I believe Attorney General Olins and Chairman Fleming both brought up that this would end up being the standard, complying with all these code sections. So the standard should not be one that we want to encourage careless behavior. We want everybody to be responsible. And therefore, some sort of showing of negligence seems something that would be important. And that's why also substantial compliance, it's not really having to comply with anything, particularly if you look at line, forgive me for my slowness here. If you look at the parameters providing who creates the guidelines, it is reviewed by the entity itself. So look at lines 78 to 79. The scale and the scope of the entity's cybersecurity program is reasonable if it takes into consideration the following items. So it's kind of like the fox watching the hen house. If I said that my security program was good enough to me, it should be good enough. I also don't see any definition, unfortunately, at line 120 regarding what an authoritative cybersecurity standard body is and who determines what an authoritative cybersecurity body is. There's some other language in here, but it sounds like the committee is open to working on the language, and I don't want to bog down the committee discussion because I know everybody's got other committees they need to go to and all.
Mr. Owens.
With regard to the last statement, we frankly had last year an earlier version that specifically referenced the 2 leading national certifications, and Legislative Council directed that other Georgia law precluded using private certifications by name in the statute. So it was candidly the thought of council that we had to put this language instead of.
Lawyers.
Everyone knows who they are. But we were told, look, we are not in the state of Georgia is not in the business of promoting certain names. So we had names. We were told that it had to be removed or else it would not be appropriate for this body to consider. Candidly, I think the suggestion that Representative Reeves had, if he was comfortable with putting the word willful, would provide that added assurance.
May I? Does that, but I think the problem there is that creates intentional conduct. And that gets us, and it makes that shield that would be very hard to penetrate, more hard to penetrate, almost impossible to penetrate when it's appropriate for it to be penetrated, if that makes any sense. I think that the more I thought about willful, we're talking about intentional conduct. And so I don't know if that's too high. I get it. And I think your position would be negligence is too low. Willful intention is probably too high. I don't know if there's a middle there, but which is why when I spoke a few minutes ago, I said we're definitely not going to get this figured out during this hearing. If this is something that the committee's interested in considering, it needs thought.
Thank you, Mr. Chairman. And I guess I would like to ask a question of Representative Reeves and Representative Abstration, because y'all serve on non-civil with me. But I believe we have a cybersecurity criminal statute. So that if there was intentional negligence on the part of an employee, that they would be charged under the criminal statute, if I'm not mistaken, correct?
Thank you, Mr. Chairman. I'm aware of a criminal trespass statute, I believe, which would potentially capture what you're talking about, a breach of private information. I'd have to think about where that might fall, but I believe criminal trespass, computer trespass is the criminal offense.
Mr. Milton, that one. Step 15.
Sir. All right. Thank you.
Yeah.
Thank you, Mr. Chairman.
Welcome. Tell us who you are and who you're with, and we'd be happy to hear from you.
Yes, sir. This will be brief. I'm Mark Middleton. I'm here on behalf of Amazon Web Services. They are interested in the bill.
You can take your mask off. The
Yes,
speaker's told us when you're addressing the mic if you'd like to.
Yes, sir.
Mm-hmm.
AWS is interested in the bill. They at a national level worked with through a national association that Senator Thompson and others working through this language that they were part of the effort in Ohio and others. So my remarks today are really more on a policy basis and just from an interest of a player like AWS who's in this space. And I think the major point that I would make has already been made a couple of times, which is having legislation like this creates an awareness to business that they need to go out and do certain things. And it gives them, businesses that don't understand, as Mr. Olens was saying, not knowing what certain things mean after a certain age, it helps direct businesses, both large and small, to a standard that they can adhere to. So we don't have anything to add to some of the legal points that have been made, the kind of wordsmithing that this committee does, but I was just here mainly on behalf of them to monitor the progress of the bill and just to I think serve an example of the type of business entity that's interested in seeing something like this done in Georgia.
Any further questions from the committee at this point? The chair's intention is this: during this unique time of dealing with the virus and our limitations on meetings, our inability to get as many folks in the room as we normally do, the problems with proponents of bills having the opportunity to reach the members and answer their questions beforehand. We normally have subcommittees, and the purpose of that is to have this free-flowing discussion we did today, so the author and the proponents have a chance to go back and then answer the questions and work out details in full committee. But because of our limitations, I'm bringing all the bills to full committee now, and it's serving that function. And sometimes there is a bill that there's consensus and there's not a lot of questions that need to be answered, and we go ahead and pass it that day. I was giving this bill a chance to fall in that category. However, I think, as you have heard, there are numerous questions. It seems like to me there's a consensus amongst the committee members that they like the concept and the idea. It's just getting the words right on the paper. So, Mr. Olins and Senator Thompson, what I would suggest to you is take the thoughts that have been expressed today. We've allowed everybody to speak that wanted to speak and also ask questions. Now you have a little time to work with the members and say, hey, does this meet what you were thinking about? You can go back to members of your committee, Mr. Olins, that helped you draw up this, draw on the experience and knowledge of other lawyers, do some research. And then the chair would like to have another meeting for you sooner rather than later. I don't know if it'll be tomorrow would be your preference, because you may need more time than that, but certainly maybe Monday. So what I would say to you is I'm going to be on standby waiting for you to tell me when you think you've accomplished reaching out to the members and maybe making some proposed changes, also potentially drawing up a committee substitute so that we're not necessarily making the amendments here, although we do that regularly, but give you that opportunity if you wanted to bring something forward. Does that make sense?
Yes, Mr. Chairman.
Okay. All right. Any further questions or comments from the committee before we move ahead? Tomorrow's Friday. It's not the chair's intention at this moment to have a hearing tomorrow. However, things change around here. And if these two gentlemen come back to me with, hey, we think we've got it, we've had a chance to talk to some folks, I certainly would consider doing that. Obviously, Monday may be a more likely possibility. So, Senator, thank you for coming today. I think this is an important area. We certainly want to encourage Georgia businesses to do what I think the bill will do, and that is to improve their security, because they'll now have there's a carrot and the stick approach to this. And the carrot is, hey, if you will do the things we're talking about here, then you will be protected if you get a criminal that tries to break into your system. So thank you for bringing this. I think it's very important, and I want to put something together that we can send to the floor and get passed for you.
Thank you, Mr. Chairman. I appreciate your time.
Yeah, we'll send
Thank you.
adjourned.